afternoon. This is Cathy Piciulo with the Kenton Chamber of Commerce, and we have been waiting for this particular one. I don't know about you, but the New York State laws have been changing, and it is something that we are trying to stay on top of, and we're very, very fortunate. We work very closely with Harter Secrest and Emery, and there is a program that they have been talking about. It's an updated program to what we had last year, which had a ton of information and was one of our best programs actually that we recorded as a speaker series. So it is about labor and employment law, and there's an overview, and then obviously some new things for 2022. And we're very excited because Chloe Macdonald and Anna McCarthy both were with us last year and are able to bring that same information this year, and they're a delight. Anna, I would love to throw this to you and introduce you, and then you guys can take it from there.
Great, thank you so much, Cathy. Looks like we might have lost Chloe a second, but that's all right because I'm going to start the presentation anyway. So hopefully she's able to sign back in, but no problem if not. So thanks to those who tuned in, and to those who might be watching this later on YouTube. This is Labor and Employment Law in 2022, what New York State employers should know. My name, like Cathy said, is Anna McCarthy, and hopefully my colleague Chloe Macdonald is able to sign back in. Both of us are attorneys at Harter Secrest and Emery in the Labor and Employment Practice Group. Just a couple of housekeeping things before we get started. First, I need to disclose that the webinar is intended for general information purposes only and should not be considered legal advice. The information in the program is not intended to create, and your attendance today does not constitute an attorney-client relationship. If you have any questions during the presentation, please feel free to throw them in the chat, or unmute yourselves at the end of the presentation and just throw the questions out, and we can address them then. So I'll move on to our agenda, which is quite varied. We've got kind of a long list of things to cover. It's sort of a compilation of the big topics that New York State employers should be aware of in 2022, including wage and hour updates that have arisen in case law, as well as some important wage disclosure requirements. We're also going to give you an overview of some new or updated protections for employees, from whistleblower protections to electronic monitoring notifications to workplace safety updates. And we'll finish up by talking about the latest on marijuana in the workplace, because that is always a hot topic. And I see that my colleague Chloe has joined us again, so yay, that's great. Okay, so moving on to our first topic. Some of you are probably already familiar with this, but it's always a good reminder to throw in just a few updates on wage and hour issues. The minimum wage in New York City has already been at $15 for the past few years, but it was increased. If you happen to have any employees that are not in this area, maybe they're located in Nassau, Suffolk, or Westchester counties outside of New York City, the minimum wage increased $1 from $14 to $15. And for the remainder of New York State, so this would be particularly applicable to this area, it increased this year from $12.50 to $13.20 an hour. And those rates are going to continue to increase across the board until they reach $15. So they're going to stay at 15 in New York City and the surrounding areas, but they'll go up to 15, or they'll continue to increase in our area until they reach 15. For employees in the fast food industry, regardless of where you are, it is already at 15. As an aside, if any of you are in the hospitality industry, there were increases in the tip credit. The tip credit is what allows employers to credit a certain portion of an employee's tips toward the employer's obligation to pay the minimum wage. But again, that's specific to the hospitality industry. And for employees who are exempt from overtime and paid on a salaried basis, we also had some increases in salary. So the minimum salary threshold increased in the New York City area from $1,050 a week, which is an annual salary of $54,600, up to $1,125 a week, which is now an annual salary of $58,000. So again, that's the New York City and surrounding areas. In the remainder of New York State, we also had an increase. So again, more specific to this area, the minimum salary threshold for people who are exempt and do not receive overtime paid on a salary basis, the minimum salary threshold went from $937.50 a week to $990 a week. So that's an annual salary now of $51,480. So some small increases there. So back to employees who are paid on an hourly basis. So we were just talking about the minimum threshold for exempt employees who are not paid overtime. For non-exempt employees, hourly employees, as you may already know, New York State has some really specific requirements for the frequency at which employers must pay certain types of employees. And specifically, there was a case that came out in August of last year that has some implications for, at the very least, manual workers in New York State. Now, the term manual employee or manual worker may not seem right off the bat to apply to a lot of people, but the definition is actually quite broad. So I'm just going to skip to this slide quickly to go over the definition, and then we'll go back and talk about the case. So manual workers in New York State are defined as mechanics, working man, or laborer. And that's a very old definition, as you can probably tell. But it's been interpreted by the Department of Labor in this state as any individual who spends more than 25% of their working time engaged in physical labor. And that's been interpreted very broadly. So, for example, it can include a janitor, a cook, a carpenter, a chauffeur, a mailroom employee, hairdressers, grocery store employees. There's quite a range of jobs that case law has specifically looked into. But the rule of thumb generally seems to be if you're spending more than 25% of your time engaged in, quote unquote, physical labor, you may be considered a manual worker. And it's best in this case, for the most part, to err on the side of caution, at least in the first instance, because of the fact that it has been interpreted so broadly. So getting back to the case, this was about manual employees, again, people who spend at least 25% of their time doing physical labor. They have to be paid weekly in New York State, and that has always been the case. That's not new. There are other frequency of pay rules, like clerical workers have to be paid bi-weekly at least. But the manual worker is what we're really looking at, because this particular case was brought by a manual worker. And he said he wasn't paid on time because he was only being paid bi-weekly. He should have been paid weekly. And the important point about this case is not whether or not the employer was paying right or wrong. It was the fact that the court held that he was A, allowed to bring that private claim in court, and B, could be paid quite a significant amount of damages if the court found in his favor. So the bottom line is these types of claims for frequency of pay issues can be brought by individual employees. They can also be brought as class actions, so a group of employees that say they're not being paid on time or at the right frequency, and they are entitled to potentially obtain quite a large amount of damages if the court finds in their favor. And another important point to know is that even if you are aware that you are doing something wrong and you fix it before a claim is filed, that is potentially still something that an employee could recover on. So even if you're aware that an employee might be upset about their frequency of pay, maybe you realize that you aren't paying at the frequency you should be, and a claim hasn't been filed yet, the employee can potentially still recover for that mistake, even if it's fixed. So bottom line is, if you're not sure if you're paying at the right frequency, definitely check into that, fix it as soon as possible. But know that if you don't fix it, that there could potentially be consequences down the line if an employee decides to file a claim. And then the final wage update I'm going to give you is a wage disclosure requirement update before I pass it over to Chloe. So what to know here? There is only one current law that you really need to be aware of, but there's some pending legislation that is on the horizon. So I wanted you to be aware of that as well. In New York City, there is a current law that will go into effect next month, early next month, that says that employers with 4 or more employees have to state the minimum and maximum salary range for any job, promotion, or transfer opportunity that is advertised. That would include both internal and external job postings. Like if you internally post about a promotional opportunity or a transfer opportunity, or if you're externally advertising, you have to show what the range, the potential range for that job is. Now, why is that important for you if you don't have New York City employees? It's important because this is spurring the state to potentially consider the same type of legislation. So, and in Westchester County as well. So there's pending legislation in Westchester County that is very similar to the New York City law. And there's pending legislation in New York State, which says that for any internal or external posting, job posting, you would be required to include the range of compensation for that job, a job description if there is one, and a description of all benefits and other forms of compensation that are offered. So this is not a current law, it's just pending legislation. It is still in committee right now, so it's not, close to being implemented into law at this point, but it's something to be aware of because the state will likely follow what the city has done, at least in some capacity. And there's been some talk about this. So definitely something to be aware of in terms of, if you feel like you need to, review what your job postings look like, or you need to review whether or not you have a job description available for a job posting, just so that you're prepared if and when the law does go into effect. So right now, just informational purposes, not something you need to worry about. But something that's on the horizon. So the takeaways from this section: make sure you're paying the minimum wage or the minimum salary threshold, making sure that you're paying workers on time, particularly manual workers who have to be paid, generally speaking, weekly, unless they're working for nonprofits, and then it can be semi-monthly. And then the fact that there's some wage disclosure legislation on the horizon for the whole state, but if you have employees downstate, it may already be effective for you. May already be something that you need to comply with. So I'm going to turn it over to Chloe for our next topic.
Sure. Hopefully my technical difficulties are over with now. That was very odd. So hello, Chloe, nice to meet you all. I'm going to do a quick update on paid family leave to get my portion of this started. So no big changes here. Paid family leave is not new news. We're all familiar with it. The benefits amount, the benefit has not changed. You get 12 weeks at 67% of the employee's average weekly wage up to a cap. Where we have seen a small change in 2022 is in the state average weekly wage. That increased to about $1,600. And because there was an increase to the state average weekly wage, we have corresponding increases to the maximum weekly benefit. So the average weekly wage went up, the maximum weekly benefit went up by about $96, and the maximum annual contribution also had a corresponding increase. Now in November of 2021, Governor Hochul signed a law that makes some changes to paid family leave. Employees can take time to care for a family member with a serious health condition. And under this new law, which goes into effect January 1st of 2023, siblings will be included in the definition of family member. So the takeaways for paid family leave: review your policies and procedures for compliance. If you have a policy, I don't see this too frequently, but if you have a policy that specifically listed dollar amounts, make sure that those dollar amounts are matching the increased amounts that are in 2022. And then as we go into next year, we've got many months to think about it at this point, but the time will go by quickly. Going into next year, make sure if you have the definition of family member in your policy that you update that to include siblings. Next topic on our agenda is the HERO Act. Again, the HERO Act isn't new. It actually went into place last summer. It has two main components. The first component is the Airborne Infectious Disease Exposure Prevention Plan, which is quite a mouthful. That is not so hot on the agenda right now. Plans should have been distributed last summer. They were in effect because the state had designated COVID as a highly contagious airborne infectious disease from about September to March, but that designation recently expired. And so currently plans don't have to be in effect. You should have a plan on deck on the books though. That is still a requirement, but you don't have to activate it at this time. The other requirement of the HERO Act is workplace safety committees. And starting in November, employers with 10 or more employees have to permit employees to establish workplace safety committees. And I think permit is a key term there. That means if employees want it, you should do it, you have to do it, but you don't have to go out as an employer and affirmatively set one of these up. You just have to permit employees to establish workplace safety committees. Employees, for determining if you meet that 10 employee threshold, is defined fairly broadly to include part-time employees, temporary employees, and seasonal employees. So when you're counting your employees, do that with a broad stroke. Now, there are some regulations that were proposed earlier in 2022. These aren't in effect yet, but they have given some insight into how New York is going to deal with the Workplace Safety Committee issue. It's given some insight as to how employees can go about requesting a Workplace Safety Committee. So under these proposed regulations, it would have to be a written request from at least 2 non-supervisory employees to request Workplace Safety Committee recognition. Now, employers need to promptly respond to a request for committee recognition. If the employer already has a Workplace Safety Committee in place that meets the requirements of the HERO Act, so the safety committee has the right composition, we'll talk about that on the next slide. If that safety committee has the right powers and capabilities, that would be a key component of making sure it matches with the HERO Act as well. If the employer already has a committee like that, the employer does not need to have 2 committees. That would be silly. So in that case, the employer doesn't have to make a second one. It should just refer those requesting employees to the already established committee. So under the proposed regs, we have a little bit more detail on what the committee would be comprised of. Based on the law, we knew that the committee would need to have both employer and employee representatives. Under the proposed regulations, we get a little bit more detail. The committee needs to have at least 2 non-supervisory employees and 1 employer representative. It's capped at 12 members, but could be less based on the total number of employees at the worksite. The committee's role is fairly broad. They can raise health and safety concerns, complaints, suspected violations of the HERO Act. They can also comment on HERO Act policies, potentially participate in on-site visits for governmental entities that are responsible for enforcing health and safety standards, and they can review employer reports related to health and safety. If you have a Workplace Safety Committee, your employees want to create one, if that committee raises a concern to the employer, under the proposed regs, the employer has to respond in writing within a reasonable time frame. So we'll continue to watch those regulations to see if they become finalized. Our takeaways for the HERO Act, going back to the first component of the HERO Act, the plan. If you haven't created a airborne infectious disease prevention plan for your workplace yet, look at the templates on the DOL HERO Act website. They're super easy to fill out, to just go through and plug in that information and have that plan on deck. And then with COVID numbers always changing, going up and down and fluctuating, keep an eye on if the state redesignates COVID as a highly contagious airborne infectious disease, thus requiring the reactivation of HERO Act plans, right? They don't have to be activated right now, but watch the HERO Act website because it may be that redesignation is coming depending on how the numbers go. If employees are requesting to form a committee, don't let that request fall on deaf ears, work with them to get that established. And if employees are raising complaints related to workplace health and safety, again, don't ignore those either.
Okay, so our next topic is whistleblower law amendment. So this actually applies to all private employers. So anyone on the call who's an employer, this would apply to you. The labor law section 740 that covers whistleblower protections is not new. So that's been around, but there are some more requirements that were added very recently, effective in January of this year, that require some affirmative action on the part of private employers. So as I said, whistleblower protections already existed in New York State labor law. And in particular, nonprofits, if you're a nonprofit, were required to have a whistleblower policy. So they already have that in place, but for those of you who don't, this is particularly important. So Labor Law 740, which again applies to all private employers, has always protected whistleblowers if they disclose an actual violation of the law that, and the quote is up on this slide, that presented a substantial and specific danger to the public health or safety. There was a requirement in the law that they would have to go to their employer first, let them know that they think that there's an actual violation going on in their workplace or committed by the employer. And then, if nothing was done about it, the individual could then take it to a public agency and whistleblow. and say, I think there's something, wrong here. So that again has always been the case. The amendment to the law, which took effect again late January 2022, expanded the rights of people under this law. So I say people, not just employees, because now it covers former employees and independent contractors. So a former employee could whistleblow and still be protected under this law, as could an independent contractor, even though they're not your employee. So there was that expansion that is a big deal. And we'll get into the amendments, the other amendments on the next couple of slides. But one other note I want to mention is the next section in the labor law, section 741, was also amended, and that applies to whistleblowing in the healthcare context. So that particular law was also amended to require healthcare employers to publish a document notifying their employees of their rights and obligations under this law. So if you're a healthcare employer, there's a specific law that applies to you. Otherwise, generally speaking, private employers, it's labor law section 740. So what are the specific changes to the law, other than the fact that it now covers former employees and independent contractors? So effective late January of this year, employers are prohibited from taking retaliatory action against an employee or a former employee or an independent contractor who discloses or threatens to disclose to a supervisor or to a public body an activity, policy, or practice of the employer that the employee either reasonably believes is a violation of the law or reasonably believes poses a substantial and specific danger to the public health or safety. So this is a change, because before the employee had to was only protected in their whistleblowing activities if they're reporting an actual violation of the law. Now they're protected if they're reporting what they reasonably believe to be a violation of the law or a danger to public health or safety. And it actually goes beyond that. It's unlawful activities. So it's a significant expansion as to what an employee or a former employee or an independent contractor could potentially blow the whistle on. And the statute of limitations for bringing a claim was also extended. So if an individual feels like after they have blown the whistle on some violation or something that they reasonably believe to be a violation, and then they're retaliated against, maybe their employer demotes them or fires them, that individual can bring a court action within 2 years of the violation or the alleged violation, and obtain some pretty significant damages, which I'll get to in a second. So bottom line is, what someone can report about and who can report has been expanded. There's also another change. So previously I mentioned that employees had to bring the violation to their employer first, and then go to a public body if the potential violation wasn't addressed. Now there are quite a number of exceptions that allow an employee to go straight to a public agency to whistleblow and not to their employer. So no notice to the employer. An employee does not have to bring their concern to the employer first if they believe there is an imminent and serious danger, if they believe that the employer would do something to destroy evidence or conceal the unlawful activity, if they feel like it would be whatever practice it is endangering the welfare of a minor, if they believe that it would result in physical harm to the employee or someone else, or if they believe that the employer is already aware of the unlawful activity and they're just not going to do anything about it. So that's a really large set of exceptions to the rule. So that means that while you can encourage your employees to come to you first to report a violation or a potential violation, they are not required to do so under law anymore in order to get these protections under the whistleblowing law. Now, I mentioned damages, and then I'm going to talk a little bit about policy or what you can do in your handbook, for example. So I mentioned that employees or former employees or independent contractors can bring court actions if they feel that the employer is violating this law, and the damages can include civil penalties of up to $10,000 and potentially punitive damages. So not insignificant remedies. So how do you address this? First things first, there is a posting requirement. So there is a notice requirement that is at that link on this slide that you have to post in a conspicuous place in your place of business that is frequented by employees and applicants for employment. If you have remote employees, I would consider sending that notice to them electronically so that they have it and that they're, on notice that this is, that there are protections for them under this law. So that is definitely required in the law, that you have to post this notice. What we're also recommending, which is not technically in the law, but would be a good idea, is to have a written policy in your handbook about this new law. So that written policy could potentially encourage employees to come to you if they have concerns before taking things to a public agency, but it wouldn't, you wouldn't be able to prevent them from taking things externally if they felt like they needed to. But having a policy in place would hopefully help employees to bring their concerns to you first, before you hear about them through a complaint that a public agency is bringing to your attention. So consider having a policy and consider training your managers on how to properly receive complaints and address concerns, before they become bigger issues. So that is the whistleblowing law. And Chloe is going to talk a little bit about a different sort of protection that was implemented very recently.
Yes, this is, I think we're all in the perfect amount of time to get ourselves into compliance with this if we are not yet, because effective on May 7th, 2022, any and all private employers in New York who monitor or intercept their employees' telephone conversations, emails, internet access, right? So if you as an employer, have the ability, want to have the ability, do look at employees' internet use, work email use, work telephone use. If you're monitoring that, then under this new law, you have to give prior written notice upon hiring to all employees that are subject to electronic monitoring. The notice given to the employees has to be in writing. So in writing, I suppose, could mean hard copy, but in writing electronically, should also be sufficient. And that notice has to be acknowledged by the employee, right? So some sort of sign off. Now, in addition to the notice and acknowledgement requirements, there's also a posting requirement for this. So employers need to post in a conspicuous place in their workplace, usually some sort of bulletin board where you have all of your other notices posted, put something up there that advises employees of electronic monitoring. And that second bullet on this slide is a quote. It is the direct language from the statute that employees need to be advised of. I will not read it because it is quite a mouthful, but that's the type of notice you would need to post in a conspicuous place in your workplace. Get yourself into compliance with this quickly if you are monitoring employees, because it will be enforced by the Attorney General, and there are penalties that start off at $500, which is not huge, but still a good chunk of change, but they quickly escalate into several $1,000 penalties for second and third and subsequent violations. The takeaways from this, employers who monitor information systems, whether that's your internet, your email, your telephones, or who want to reserve their right to do that in the future, which, really everyone should start looking at their current notices and policy language to get that into compliance now. I mentioned that notice and acknowledgement requirement. This could be something that's part of a handbook. You would want to incorporate that there. If you do have policies related to internet use, email use, phone use in the workplace, you'll want to make sure those are updated to reference monitoring as well. And then implement the required notice and posting by May 7th at the absolute latest.
Chloe, I had a question on that from one of our members. Can the electronic monitoring notice be posted on the intranet, or does it have to be a physical poster?
I would say if the workplace has a physical location, right? If it has a break room, a home office, if everyone's working from home, I suppose there's no place to post it.
There really isn't, yeah.
If everyone's working from home, then I think posting it on an internet, sending out a link to let employees know where to find it, right? So it's not just posted on internet and nobody ever gets notice that it's been posted. I suppose if everyone's working from home, you can't post it in the workplace because the workplace is not a physical location. But if there is a physical location, I would do it both.
Thank you.
Mm-hmm. Good question. Something that we all need to get used to is how many people are working remotely nowadays. And really for those remote employees, posting things on an internet is something that they are way more likely to look at than something in a physical location that they may never go to. So our next update is on the New York retirement plan. In October of 2021, the governor signed a law stating that private sector employers who do not provide their employees with a retirement plan option must automatically enroll their employees in the New York State Secure Choice Savings Plan. And you're probably wondering, why have I not heard about this yet? And we'll get to that. To be covered by this law, the employer has to have been in business for at least 2 years. They must have had at least 10 employees during the previous calendar year, and they must not offer any sort of qualified retirement plan to their employees. So they don't offer a 401k option, 403b, etc. Nothing is provided. Enrollment will be automatic, but employees can choose to opt out, and it will work through payroll deductions, and then those deductions will be sent to the savings plan. Although this was effective immediately, there's nothing for employers to do, or really anyone to do, until the program itself launches, which has not occurred. And I looked around today and I couldn't find anything indicating when the program would launch. So we will all just sit tight. Our takeaways are, if you are covered, if you look at that definition, right, you've got over 10 employees, you've been in business for over 2 years, and you're not offering any sort of plan, you're going to want to monitor closely for the implementation date. Once the program opens for enrollment, right, once it has launched, employers will have 9 months to set up that payroll deposit system. So be on the lookout for additional details regarding the program.
And I'll let you know, we're going to be doing extensive information about this. This is a biggie. And we'll be hosting separate speaker series events on this.
That is very understandable. Yes, that is a big deal, and it'll impact a lot of people. So I guess we will all sit tight and wait for that.
Yeah.
All right, back to Anna. Okay, so we're going to move on to some COVID-related stuff because we are still not rid of COVID. So one of the things that a lot of you may have experienced over the past couple of years is allowing employees to telework. Maybe, on one-off situations, maybe your entire office or your entire workforce was working remotely, depending on, what you do as a business. But regardless, a lot of people started moving into the remote working territory. And the EEOC has said that allowing someone to have teleworked during the pandemic is not necessarily determinative of whether or not you have to continue allowing them to telework now that COVID rates are lower and you have more ways of dealing with COVID. Vaccines are available, things like that. The problem is you may have difficulty as an employer arguing that teleworking is not feasible for your business if you allowed it during the past 2 years. So you don't necessarily have to allow teleworking as an accommodation. And we're specifically talking about teleworking as an accommodation here. Obviously, teleworking, whether or not someone needs it as an accommodation for a disability, is still an option that employers can give their employees. But right now, we're specifically talking about EEO issues. So this is if somebody has a disability and is requesting an accommodation that might include telework. And the question is, do you have to allow that? And again, the EEOC has said that even if you allowed it during the pandemic or during the past 2 years, that's not necessarily determinative of whether or not you have to continue allowing it or allow it now. But it may be a factor because typically when an employer considers an accommodation request for a disability, one of the things they have to consider is, does it pose an undue hardship on me as the employer? Am I able to do this without it significantly impacting my business such that it causes an undue hardship? If it doesn't, and it's workable and the person can perform the essential functions of their job, then it seems like it may be an option for the employer to allow that particular type of accommodation. But if it poses an undue hardship, if it doesn't allow the employee to perform the essential functions of their job, it may not be a feasible accommodation. So here, it would be difficult, maybe not impossible, but it would be difficult to argue that teleworking, a request for an accommodation that includes teleworking, would pose an undue hardship if you've previously allowed it over the past 2 years. So the employee can say, well, clearly it worked over the past 2 years. Why is it different now? Unless there was a change in job circumstance or something like that, that's obviously different. this is very much a case-by-case analysis, and there are no sort of broad stroke answers. But the bottom line is, if you've allowed it in the past, it may be difficult to argue you can't provide it in the future going forward. There have been a few related lawsuits, one in particular that was filed last fall by the EEOC, claiming that an employer engaged in disability discrimination when an employee with a heart condition, which the employee claimed increased the risks related to COVID, was terminated after he requested telework as an accommodation. So the employer said, no, you can't do that. We're going to fire you instead. So the EEOC filed a lawsuit on behalf of that employee, alleging that the employer engaged in discrimination. Now that case is still ongoing, unclear where that's going to go, but just be aware that that is the position that the EEOC has taken, that, you know, denying telework as an accommodation could potentially be an issue. It doesn't mean you can't deny it. There's no rule that says you absolutely have to allow teleworking, but it certainly is not a situation where you just want to say no without analyzing the situation to determine whether or not that's the right way to go. Another related issue is we've seen long haul COVID people with long haul COVID symptoms, potentially needing to claim a disability, or potentially having a disability that would qualify them to have an accommodation under the Americans with Disabilities Act. So that's just something to be aware of. It's sort of cropped up, obviously, over the last couple of years as people with long haul symptoms have found it maybe difficult to return back to the work that they were accustomed to doing prior to having COVID. And there are definitely some potential for retaliation claims, denying telework as an accommodation, or retaliating against someone by, lessening their job duties, or not giving them a promotion because that person has been, dealing with long haul symptoms or needing an accommodation. That can definitely be an issue. So just things to be aware of. All of this is very much a case-by-case analysis. So again, it's hard to give broad stroke answers, but all of these things are just things you should be aware of if an employee brings them to you. And relatedly, a couple more cases, just some interesting information to be aware of that were filed related to COVID. The first is a case in the Southern District of Florida. Neither of these cases have reached their conclusion. They were very recently filed. And they're in the early stages. So there's really nothing to glean from them other than the fact that they are cases that were brought by people. So the first one was a former employee who alleged that he was fired 2 weeks after returning from a COVID quarantine because his employer feared he was still infectious. So he claimed disability and age discrimination. Again, the case is still pending, but the employer tried to get the case dismissed and was not successful. So it's continuing on. In this case, he said he was denied remote working, even though he had done it in the past. And he was also subject to, he claims, harassment and discrimination, including the fact that he had to, once he came back to work after a negative test, continue to sanitize his workspace 4 times a day. He was chastised when he attempted to use other office equipment. He was told to stay away from other coworkers. So he's claiming that he was harassed because of the fact that he had COVID. Even though he presented a negative test before coming back to work. So that is an ongoing case. Another ongoing case is this next one, Fields v. Board of Trustees. This is a former biology professor at Georgia Military College who sued the school's Board of Trustees, claiming he was wrongfully fired for asking to work remotely during the pandemic due to his compromised immune system. That case is also still ongoing. There's really nothing, again, to glean from it in terms of what the court's going to decide, but it's just another situation in which a denial of a teleworking request has raised issues. So takeaways, I think, are to make sure that you're reviewing your policies and procedures and making sure they're compliant with laws that already exist, like the Americans with Disabilities Act, if that applies to your business, but generally speaking, making sure that you have an open mind when employees come to you with related requests, and making sure you're training your managers to not just outright deny accommodations requests, making sure that HR is looped in, making sure that things are documented, because if it's not documented, it didn't happen in an agency's eyes or a court's eyes. So making sure you're documenting your thought process, your justification for denying or agreeing to an accommodation, and to, again, assess workers on a case-by-case basis to make sure that you're making a decision that works for that particular employee and not sort of painting the whole situation with the same brush. All right. The next topic, I believe the last one before we get to marijuana, if I'm not mistaken, is updates on the NLRB. So the National Labor Relations Board takes up cases very often involving unionized employees, but even non-union employers should pay attention to this because there could be implications for you as well. So some of you may be aware that the National Labor Relations Board that takes up cases about employees' rights changes depending on the administration that's in office. So the president, the current president, will appoint members to this board, and so they tend to change in terms of political persuasion with the change in administration. So now that we have a Democratic president, we have a Dem-controlled board and a general counsel, Jennifer Abruzzo, who was also more left-leaning, more employee-friendly. So there aren't really any major changes to report on, except that the board composition has changed. And with that, you should be aware of the fact that we should be expecting a change in sort of a more employee-friendly bent to the board and their decisions. So they actually issued a memo last August where they identified several cases that were decided by the board appointed by President Trump, former President Trump, that this board, this current board, may shift away from. And that includes cases involving employer handbook rules, confidentiality provisions and separation agreements, the scope of protected concerted activity, which are activities that employees are protected if they engage in them for their mutual aid or protection. So if an employee is talking with another employee or complaining with another employee about their wages or their terms of employment, that would be considered a protected concerted activity. They're doing something, two or more employees are doing something for their mutual aid or protection, including just complaining about, for example, their wages. So anyway, the bottom line is we're going to see a more employee-friendly stance in some of the decisions that this board is going to issue. And one of those, and many of those cases may have to do with employer handbook rules and the activities that employees are allowed to engage in without fear of retaliation. So the unhelpful takeaway to this one is just to continue to monitor. It's just something to be aware of. If there's a major case, it's certainly going to make news, especially in employer circles. So just be aware of the fact that we may be seeing some changes in the way that the NLRB addresses things like handbook rules and confidentiality and protected activities. And I actually forgot, before we get to marijuana, we have one last topic I believe that Chloe's going to talk about.
On the topic of federal employment and labor law issues, we've got another piece of, well, the board is federal, and now we've got a piece of federal legislation to talk about, which was signed by President Biden in March. So this act, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, really does what the name says it's going to do. It amends the Federal Arbitration Act to permit an employee who alleges sexual assault or sexual harassment to invalidate pre-dispute arbitration agreements. So if an employer has a policy or has an agreement that's signed by incoming employees saying, we as employees agree to arbitrate all claims against you, employer, that agreement would be able to be invalidated if the employee was bringing a claim for sexual assault or sexual harassment. Employees can certainly choose to arbitrate those claims if they want to, but they don't have to anymore based on this amendment. Takeaways for this: if you do have a policy that requires arbitration, you should revise that to ensure compliance. Be aware that if you have a policy or an agreement that requires arbitration of all claims, employees can invalidate it now for sexual harassment and sexual assault claims. And now on to our last topic, which is marijuana use in the workplace. Again, not new news that New York State has legalized recreational marijuana. That happened right about this time last year. As part of the packet of legislation that legalized recreational marijuana use in New York State, there were amendments to Labor Law Section 201D. And in the labor and employment attorney world, we call this the lawful off-duty protection law. And so lawful off-duty use of marijuana is now protected under Labor Law Section 201D. Employees who are legally using marijuana cannot be discriminated against by their employers. They can't be disciplined. Employers can't take adverse action against their employees for the employees' off-duty use of marijuana. Employers are protected if they are using marijuana outside of working time, off the employer's premises, and without use of an employer's equipment or property. Sometimes I get eyebrows about what do you mean equipment or property? I think the common example there is the company car situation. Perhaps if you had given your employee a company car, the employee is using that as a personal vehicle or bringing that home with them, you could prohibit them from using marijuana in that piece of the employer's property. And the law does create a private right of action for aggrieved employees who believe that they have been wrongfully disciplined or had some adverse action taken against them based on their lawful off-duty use of marijuana. Now, this doesn't mean that employers can never take disciplinary action based on marijuana use, but the times that an employer can take action based on marijuana use are very limited under this law. The first bullet and the last bullet are the same, so I'll talk about those together. They're very similar. Employers can take adverse action if they need to based on compliance with the state or federal law, or when it's required so that the employer doesn't lose a federal contract or federal funding. The most common example that I think comes to mind where there's a federal requirement for marijuana testing or adverse actions based on a positive marijuana test is DOT regulations. Because for those drivers, there certainly can be drug testing requirements that employers would still need to meet under federal DOT regulations. The other example or exception of when an employer can take an adverse action or discipline an employee is when the employee is in the workplace and they are suffering impairment, they are manifesting specific articulable symptoms of being impaired by marijuana, and that impairment is decreasing or lessening or having some sort of negative impact on the employee's performance of their work duties. So it is not enough to just be impaired, you have to be impaired, showing symptoms and suffering performance issues, or you have to be manifesting symptoms, impaired, and your impairment is interfering with safety and health in the workplace as required by state or federal OSHA type laws. So there's a couple different requirements in there. And when you lay it all out, you can see it might be difficult to have all three of those things to be able to take action based on an employee who's exhibiting symptoms of impairment in the workplace. New York State issued some FAQs related to recreational marijuana in October of 2021. The link is there. It's an FAQ, so it's a pretty short read. And if you have any questions about how the state is going to implement this or how they're going to view employers taking adverse action based on marijuana use, take a look at this FAQ because it'll give you a pretty big clue. Generally speaking, the FAQs take the position that drug testing for marijuana is prohibited unless it is required by federal law. The law itself didn't really address the role of drug testing as far as Labor Law 201 went. As a practical matter, it didn't seem like drug testing would be all that helpful if you couldn't really do anything with the result, but the FAQ makes it more clear, right? Drug testing for marijuana, don't do it unless it's required by a federal law or a federal contract. Specific articulable symptoms, I was hoping, perhaps others were hoping, that we would get some guidance from the DOL on what those symptoms might be that employers could be looking for, but we did not get clarity in that. It has to be observable, but we don't have any sort of indication at what type of symptom we should be looking for. The guidance did make clear that a drug test cannot be used to demonstrate that the employee is impaired, which makes sense because a drug test for marijuana isn't necessarily going to show current impairment. If your employee had been using recreational marijuana over the weekend and right, they're drug tested on a Wednesday, it may be positive. That does not mean that they are currently impaired by marijuana. So a test cannot be used to demonstrate impairment, and smell alone is not going to be enough. So just some high points from the FAQs and a few more high points on our next slide. So employees can be prohibited from using marijuana during work hours. The guidance clarified that work hours includes paid and unpaid breaks and meal periods, even if the employee leaves the workplace. So an employee goes out to lunch, it's during their workday, it's their lunch break. That does not mean that they can go out and use marijuana during their unpaid lunch break. And employers can also prohibit marijuana use during on-call time. You wouldn't want an employee to use marijuana right before they come into workplace if they get called in. So again, that makes sense. A consideration for our work from home employees. If your home is your workplace, then employers can't prohibit you from using or possessing marijuana in your home, generally speaking, right? I'm in my home right now. Harter Secrest couldn't prohibit me from having marijuana in my home. However, employers can discipline an employee if they are, again, exhibiting specific articulable symptoms of impairment that are impacting their performance while they are working from home. And the guidance lastly clarified that this does not apply to employees who are working remotely in other states. Our takeaways from this: review your policies and drug testing procedures. If you are still testing for marijuana, testing your employees for marijuana, take a really close look at that. Can you tie that to a federal requirement or a state law requirement? If it's just permissible testing, right? If the federal law says you can test employees for marijuana, you're allowed to test employees for marijuana. If the federal contract says you may do this in order to keep this contract, if it's permissible but it's not a requirement, I think New York State's going to take the line that you shouldn't be doing it. So make sure that it's based in a requirement. And then our second point here: train your supervisors and managers. You want to make sure that we're not taking adverse action against employees for marijuana use. So if they said smell is not enough. So if you've got an employee who strolls in and it smells like marijuana, but are not, exhibiting symptoms that are impacting their performance, they're not impacting a safe or healthy workplace. Them just smelling enough is not enough for a manager to say, you've got to go home, or we're going to write you up for this, right? It wouldn't be enough to just have that. So train your supervisors and managers or people who are going to be kind of implementing this in the workplace to make sure they are aware of the new requirements under Labor Law 201D and the restrictions that it imposes on employers. And with that, with 6 minutes to spare, we are all done. And we're happy to take questions. I'm not sure if that will be on the recording or not, but thank you for having us.